Please be seated. Call the first case argument at this time. The matter of Sophia Ann Monroe versus Edward David Monroe. Counsel?
Good evening, Your Honors. Mr. Chief Justice, may it please the Court. My name is Cody Wilcoxon, and I, along with my co-counsel, Ms. Kim Sachs, represent the appellant, Sophia Monroe. This evening, I will discuss the issues with the contractual approach to embryo disposition. Ms. Sachs will discuss the balancing test approach and contemporaneous mutual consent approach to embryo disposition. We would like to reserve 2 minutes of our time for Your Honor, over the next hour, you will hear arguments that paint case law in this area in a negative light for my client. However, it is important for this court to recognize that no court in the United States has ever enforced an informed consent agreement dictating disposition of embryos that foreclose one party's final chance at genetic parenthood.
What case law do you have supporting your position?
Your Honor, 2 cases have faced infertility of one of the parties. That is Reber v. Rice in the Superior Court of Pennsylvania and Zafransky v. Dunstan in the Illinois Appellate Court. Both of those cases ruled in favor of an infertile mother having the right to implant the embryos over the objection of their former partner.
But with this case, the starting point here has to be, is it not, the existence of this agreement?
Certainly, Your Honor. While the role of an informed consent agreement is an important health protocol that helps establish the inherent risks of these procedures and establish the rights between the gamete providers on one side and the clinic on the other, my client is contending that there was no mutual assent to an agreement between Ms. Monroe and Mr. Monroe.
But the agreement was quite clear, wasn't it? It asked you to read it, consider it, to say whether or not you agreed, and you're not suggesting there was any ambiguity in terms of what was at stake, are you?
No, Your Honor. My client has conceded that this agreement was unambiguous. However, it begins on the first page of the informed consent agreement found on page 18 of the record that it unambiguously asked the parties sign this agreement as a condition precedent to undergoing IVF procedures.
What's wrong with that?
That is inherently coercive, Your Honor, and applying the
If I
contract.
sign a lease agreement with Hertz and they don't let me take the car out of the garage unless I sign the agreement, does that mean that I'm being unduly coerced and when I rent their car, that contract can't be enforced?
No, Your Honor, this is not implicating greater contract law. As the Rhode Island legislator has spoken, the difference between these family interest contracts and those of traditional business contracts have required and have allowed the legislator to speak that courts have a special oversight duty to make sure these agreements are entered into equitably.
Well, you're not suggesting that the entire agreement is invalid, are you? You're only concerned about the informed consent provision, is that right?
That's correct, Your Honor.
Isn't that essential, however, to the other party to the agreement? What assurance can the clinic have here of concerning disposition of these embryos if they don't have some agreement from the parties as to what's to be done with them? They're the repository for these pending their eventual use, are they not?
Yes, Your Honor. Certainly there is some stability necessary to these clinics, but requiring a dispositional agreement is taking Mr. Monroe and Ms. Monroe's procreative autonomy and making it a non-negotiable clause in a contract of adhesion.
But as you've just said, the agreement was applicable to both Mr. Monroe and Mrs. Monroe.
Yes, Your
Doesn't
Honor.
that matter?
Yes, Your Honor. My client's contention is that this contract was between Ms. Monroe and Mr. Monroe as one unit of gamete providers and the clinic.
You're not going back to entirety of these concepts, are you? Fencing the entirety? That it's one unit? You're not arguing that?
No, Your Honor.
If you get into rule against perpetuity,
Well, you're talking about life and bed,
No, Your Honor. We are saying that in the context of this contract, the parties were asked to establish their rights as a married couple on one side and between the clinic on the
Either
other.
one could change their mind under subsection G. At any point during the course of the contract, either one could change their mind. The contract specifically provided for what would happen in the event of certain contingencies, and that's why we're here. There was a contingency. And why should courts get into this business to begin with? Why shouldn't we simply allow the parties to work these things out themselves?
Your Honor, I respectfully disagree with your interpretation of Section G of this agreement. While it pretends to allow modification or withdrawal, it does so in a way that handcuffs Ms. Monroe's procreative autonomy to that of her ex-husband.
But
It does-
it not only does that, this isn't the standard contract of adhesion situation, is it? I mean, a contract of adhesion is one which is not open to being changed in any way. Isn't that the case? It's essentially a take it or leave it bargain.
Yes, Your Honor.
And there are three options provided here, right? That's not the usual contract of adhesion setting, is it?
Your Honor, this contract was presented in a way that requires signatures in each of these forms to undergo IVF treatment. And while there are three options available, none of them allow the parties continued procreational use after divorce, which is a standard dispositional.
Did you decide to write that in as one of the cases that you cited to us where the party wrote in another option?
Yes, Your Honor. In one of the cases, AZ v. BZ, the informed consent agreement allowed a line where the parties were able to put that agreement into the informed consent agreement. One of the solutions that my client would like to bring
Why
forward,
couldn't that have been done here?
Your Honor,
I was doing this, 1, 2, 3, I write in 4, and I write it in. Why couldn't that have been done here?
Your Honor, there was no space available for Ms. Monroe's.
I'm showing you the space, it's right here. Between that line and that line, you write it in.
Your Honor, there was not a blank space that made Ms. Monroe believe that she could fill that in.
Did she ask?
She did not ask, Your Honor.
How many of these agreements did your client sign?
She signed 2 of these agreements, Your Honor.
All right, let's assume, just for purposes of argument, that you are correct with respect to the first such agreement. Why the second?
Your Honor, Ms. Monroe understood that this was a condition to undergoing IVF treatment. As the family court and her ex-husband have described her, this is a woman that was obsessed and desperate with having a child, and she knew that her signature on this page was a condition to undergoing IVF. At the time, she did not understand that this contract, after 9 pages of establishing rights between the party and the clinic, would then establish a second.
Contracts inherently are intended to bring order to a relationship of some kind. Ordinarily, they may be commercial in nature. This one clearly has implications beyond commercial, though it is certainly commercial in nature as far as the clinic is concerned here. But why isn't the position you're taking a suggestion that any party based on changed circumstances can avoid her obligations just because there has been a change in circumstances?
Even when the change is foreseeable.
Your Honor, my client is not trying to skirt a legal obligation here. She certainly acknowledges.
How come you know that? You said she signed the contract. Contract's not ambiguous. You've used this term contract in referring to this document many times. You don't want us to enforce the contract, and then you just said she's not trying to skirt the contract. Am I missing something on that?
Your Honor, my client never entered into a legal obligation between herself and Mr. Monroe, the 2 parties to this dispute. They never mutually assented to this dispositional agreement intended
What
to be
difference does that make?
Your Honor, my client never intended for this disposition between herself and her husband to be binding in the event of a divorce. And furthermore, Your Honor,
Read it. It's specifically provided for.
Your Honor, this advanced directive was meant to provide instruction for the Kent Fertility Clinic upon these contingencies. However, Kent Fertility...
What are these contingencies?
The contingencies listed are divorce, death, incapacitation. However, Your Honor, I would argue that there is a 4th contingency that is not contemplated here, which is infertility.
Why isn't that incapacitation?
Your Honor, incapacitation in these terms, I believe, is referring to incapacitation of the party as in unable to make those own decisions. However, in this case, the family court is imposing this contingency of divorce. However, if the couple had simply just gotten divorced, Ms. Monroe would be able to go to the Canned Fertility Institute, have more eggs harvested, and fertilized by a sperm donor, which would not implicate any of these issues we are speaking of.
You'd have no problem with that?
No, Your Honor.
You just had to sign an agreement like this?
Your Honor, if that were the case, if that were the contingency that was truly being implicated, then my client would not have an issue. However, in this case, the contingency was not...
less duress in that situation than there is in this situation.
Your Honor, in this case, my client is infertile due to harsh chemotherapy treatment. Fertility is one of the basic assumptions of undergoing
The example you
IVF.
just gave me, she's also infertile.
Could you repeat that question, Your
The
Honor?
example you just gave me, she would also be infertile.
In-
That's why she's going to the clinic, isn't it?
No, Your Honor. If she was infertile, she would not be able to go under IVF treatment. One of the cornerstones of undergoing IVF treatment is your fertility. They have to be able to harvest your eggs, which requires fertility.
You're also, I mean, getting away from the words of the contract, you're also asking us to hold that the contract is just against public policy, is that right?
Yes, Your Honor.
And I mean, how do we go about making that seemingly subjective inquiry?
Your Honor, this court established under Gorman versus St. Raphael that there are 4 factors that could establish that a contract violates public policy. One of those 4 factors is unconscionability.
So let's take a different situation. Assume that your client entered into an adoption agreement whereby she gave away a child through adoption. She tragically developed cancer. She was no longer able to give birth to a child. And a year later, she went back to the person that she who adopted her baby and said, I've got to rescind the agreement. This is my only opportunity to procreate. I mean, is that agreement enforceable?
Absolutely, Your Honor. In this case, why infertility changes the circumstances is because fertility is one of the basic assumptions of undergoing the IVF procedure.
What is the public policy that is at stake here? Identify the Rhode Island public policy that you seek to vindicate by your client's position.
Under the Gorman test, this court has established that unconscionability in a contract is a violation of public policy.
That's certain. They're saying it's unconscionable because it's against public policy. It's against public policy because it's unconscionable. That doesn't help. At least doesn't help me much.
No, Your Honor, I'm not saying that it is unconscionable because it violates public policy. I believe this
Doesn't
contract...
unconscionability have to be a factor that exists at the time the contract is entered into?
Yes, Your Honor.
That's the point when it is unconscionable.
Yes, Your
So
Honor.
why is this agreement unconscionable at the time the parties enter into it?
Your Honor, unconscionability is found through a sliding scale of procedural and substantive unconscionability. In regards to procedural unconscionability, as I mentioned, this contract was presented to the Monroes as a take it or leave it form that required the condition of signing each of these forms, including the dispositional form, as a condition to undergoing IVF treatment.
How about substantively?
Substantive unconscionability, the party was not offered any meaningful bargaining power or the meaningful choices in this disposition. While your honors, you are correct that there are 3 selections, none of them allow the parties to exercise their true procreative autonomy and allow them to keep these embryos for procreation after these contingencies are met.
But they knew that when they entered into the agreement. That's my concern with your argument. And they had signed the contract twice, and they did not ask, she did not ask, for an additional alternative other than the ones that were, the 3 that were put forth in the contract, and with the contingencies that brought us here.
Your Honor, it's important to note that neither of the Monroes received any education past high school, and it is a little subjective to say that they would be able to understand this medical jargon and all of the...
We're talking about subsection F. What medical jargon do you see in subsection F, other than CFI, which they must have understood, because at the very top of the page it says Canton Fertility Institute. I assume that's what CFI means.
Yes, Your Honor.
What medical jargon is in that provision?
This contract is presented in such a daunting way that the first 9 pages include all the inherent risks and the rights of the Canton Fertility Institute, and then all of a sudden, this is asking the couple to establish a second contractual relationship within the context of one contract.
Well, read the contract. Read the contract. Because of the possibility that you or your partner's separation, divorce, death, or incapacitation after embryos have been produced, it is important to decide on the disposition of any embryos. I don't know how it could be clearer. They do have the word cryopreserved in parentheses, but that's not at all material in this. I don't know how it could be clearer.
Your Honor, my client has conceded that it is unambiguous. However, in the context of IVF, having one document to establish all of these rights is typically considered unconscionable, where most clinics that have these dispositional agreements apply do so as two separate contracts, one to establish the rights between the party and the clinic and to explain the inherent risk, a second to establish the right between the parties and themselves. This is, for example, is done in the Finley case in California. Furthermore, Your Honor, we would like the court to consider a contingency of infertility separate from that of divorce. As a result, my client asked this court to reverse the holding of the Rhode Island Family Court and rule in favor of my client. Thank you.
Thank you. We'll have your side back on rebuttal. Ms. Sack?
Good evening, Your Honors, and may it please the Court. My name is Kim Sachs, and I represent Appellant Sophia Monroe. As my co-counsel stated, this is a case about preserving my client's last chance at genetic parenthood after harsh chemotherapy treatment rendered her infertile. In the absence of an enforceable agreement, courts determined the disposition of frozen embryos using two approaches: the contemporaneous mutual consent approach.
Which makes no sense to me. Mutual assent makes no sense whatsoever.
Yes, Your Honor, my client agrees with you. The contemporaneous mutual consent approach is completely unrealistic. If individuals could reach a mutually satisfactory agreement, they would not be in court. This litigation began in 2014.
What's the other one?
The balancing approach, Your Honor, where the courts consider the interests of both parties.
Why isn't that nothing more than us putting our values into the case and deciding the case based upon our personal values and nothing else?
Your Honor, the balancing approach is a fact-based analysis, and the Davis versus Davis Court recognized factors for courts to consider, including the
But the court had to assess the strength of those factors, and it seems to me all they were doing was the court was putting its own assessment of the individual values onto the scale and balancing it.
Yes, Your Honor. Unfortunately, under the balancing approach, the court does have to consider the interests of the party seeking custody of the embryos and the party seeking
It's not just considering the interest, it's putting a qualitative assessment on those interests and weighing them
Yes, Your Honor.
based upon our values.
Yes, Your Honor, but it's also considering the values of the party seeking custody of the embryos and the party seeking to avoid.
The court below gave virtually no analysis to this issue and why we should apply, why it thought courts should apply a balancing test, didn't it?
Yes, Your Honor.
Like one sentence of analysis.
Yes, Your Honor. And I'd like to remind you that this is a case of first impression in Rhode Island. In this case, this court has the power.
All the more reason to give us reasons for why this is the more appropriate test to apply.
Yes, Your Honor. The contemporaneous mutual consent approach is, again, completely unrealistic.
Well, why is that? I'm not sure I accept that premise. I mean, at least under that approach, it puts the onus on the parties to come to some resolution, and in the meantime, leaves the embryos existing, frozen, and not destroyed, whereas the balancing approach does put the onus on the state and the courts to make that determination.
Your Honor, in Davis versus Davis, the court recognized that two rights of equal significance exist: the right to procreate and the right not to procreate. However, the contemporaneous
Not the
mutual...
right, I mean, are there any rights that we should recognize in the embryo?
Your Honor, this court has discussed whether embryos are persons or property. In Frazina,
What are they?
In Frazina, this court said that embryos were not persons to recover under a negligent infliction of emotional distress claim. However, this court has never discussed what embryos are.
Clearly, they're not property. You would concede that, right?
Yes, Your Honor.
Okay, so then they're persons.
Yes, Your Honor.
When you say yes, Your Honor, is there mid-ground? Is there mid-ground? Could it be a particular class of entity, be it property or person?
Yes, Your Honor, there could be, which brings me to the psychological burdens that disposing or donating these embryos would impose.
Well, before you get to the psychological, just so I'm clear, do the interests of the embryo, the potential life not being destroyed, factor into the balancing analysis or not?
Your Honor, past cases have not factored that into the balancing approach, but because this is a case of first impression in Rhode Island, this court could consider that in its analysis.
And which way is that? I mean, is that your position that we should?
Your Honor, you should, and you should protect life and keep these embryos alive and treat them as persons.
Something that we've not addressed so far in this argument, did not with your colleague a few moments ago, what is the standard of review that we should apply when it is an application of the balancing test?
Your Honor, at the very least, the application of the balancing test would be a mixed question of law and fact, which
Why?
would be
When a court is considering so many factors and doing just that balancing, why isn't an abuse of discretion standard more appropriate?
Your Honor, because the balancing test is a fact-based analysis, but it's how the facts apply to the law under the balancing approach. And so this court
Let's
should...
answer the question, but let's explain what the test is. Why shouldn't we look at what the trial court did and determine whether we agree with what the district court concluded? Did the district court abuse his discretion in concluding that? Why wouldn't we look at it that way?
Because this is a mixed question of law and fact at the very least, which is subject
Well,
to...
you said we shouldn't look at it that way because we shouldn't look at it that way. That's what your answer says.
Your Honor, you shouldn't look at it that way because, in general, mixed questions of law and fact are subject to de novo review, not subject to abuse of
Well,
discretion.
factual determinations are subject to clearly erroneous review by themselves. Mixed questions are indeed subject to plenary review, to de novo review. But what's the question of law that's wrapped up in this mixed question?
Yes, Your Honor, how the balancing approach, how the facts apply to this balancing approach.
What would we be deferring to? And as Judge Smith said earlier, it's a sentence in the opinion on balancing. And it seems to me either we would remand it, and why wouldn't we remand it for more reasoning, or apply de novo? I mean, what do you think we should do?
Your Honor, my client does not want you to remand this case. Her biological clock is ticking, and that would just result in more litigation.
Her clock, I thought she was infertile. And the embryo, you're suggesting that the status of the embryo is going to change whether or not it's remanded or not?
No, Your Honor. Women can only safely carry a child to term past a certain age, and she's in her early 40s, and so if she were to get custody of these embryos, she could only implant them and bring them to term until a certain age.
How many does she want to implant, by the way? I mean, is it potential of 7 children
Your Honor, my client wants a genetic child, and once she achieves that genetic child, she can no longer implicate Mr. Monroe's right not to procreate. However, Your
here? I
Honor...
don't understand that. I mean, if she gets 1, is she going to stop there, or is she going to keep going until she got up to 7?
Your Honor, IVF procedures result in a live birth only 30% of the time, so it seems unlikely that 1 embryo will actually implant, let alone 7. However, Your Honor, I'd like to...
But your position is that she could keep going. So just in terms of weighing and balancing the right to procreate versus the right to avoid an unwanted family, I mean, we should assume that there could be 7 children, not just 1.
No, Your Honor, you should assume that there will be just 1 child.
You just said, given the odds of survival, there's going to be more than 1 embryo is going to be implanted.
No, Your Honor, she would have 1 embryo implanted first, and then if that didn't work, she could implant another one.
Chances are it would, so she implants the second one. So that doesn't really answer the question.
Your Honor, if the first embryo did not gestate, then the second embryo would, and that wouldn't result...
Wait. The chances of the embryo gestating are the same, right? It's like flipping a coin. If I flip a coin 99 times and it comes up heads, the 100th time, there's still a 50-50 chance of it coming up heads or tails. So the fact that the second embryo is implanted after the first embryo fails doesn't change the likelihood of success of the second implantation, does it? It's still 30% from what you said.
Well, right, Your Honor, it is not 50%, it's a 30% chance, which again...
So that one fails, chances are that one fails. Now we're up to the third one. Still 30% chance of survival, right?
Yes, Your Honor.
Chances are that one fails. So that doesn't answer the question. We go through all 7.
Your Honor, the fact that these embryos continue to fail just tips the balancing scales more in favor of my child, because it seems unlikely that the embryos might implant, which would not implicate Mr. Monroe's right not to procreate. However, this court should look at other factors in the balancing approach. In Davis versus Davis, the court said that courts should balance the interests of both parties. However, every court that has applied the balancing test has focused almost exclusively on the burdens of the objecting party. In Davis versus Davis, for example, the court dedicated 3 full paragraphs to Junior Davis's burdens, talking about the financial, psychological, and constitutional implications.
What about the financial burdens? I mean, am I right that you've committed not to seek any financial support, and how would we implement that, or how? And what's to say you wouldn't go back on that promise as well?
Yes, Your Honor. My client concedes that in State v. Fritz, this court said that no parent can waive or contract around their child support obligations. However, in Reber versus Rice, which was decided in Pennsylvania, Pennsylvania has the exact same statute. And in that case, the court said that individuals can come to a private agreement regarding child support so long as...
Why wouldn't that agreement be unduly coerced? The same thing that your colleague argued to us to show that this contract was unduly coercive and shouldn't be enforced. To make that exact same argument about any waiver of the right you'd otherwise have to go after your former husband for support. Unduly coercive. I had to do it or I couldn't have the embryo implanted. I had no choice. I was under duress. It's the same argument. Why should we pay any attention to it?
Your Honor, because Ms. Monroe can indemnify Mr. Monroe for any child support obligation he would have to pay, she could identify a guardian in her will who would take care of the child in the event.
Well, she had the money to indemnify him for child support. I assume she'd have the wherewithal to pay the child support herself and wouldn't have to go after him for it.
Yes, Your Honor. And in the state of Rhode Island, I'd like to point your attention
See,
to...
I'm having a hard time understanding your position. Are you suggesting that your client, as the parent of any child that might spring from the eggs here, could waive the child's right entirely to receive support?
No, Your Honor, that right lies exclusively with the child and
Exactly.
remains with the child.
I thought you were.
Yes, Your Honor. So Mr. and Ms.
Yes, you
Monroe...
were agreeing that?
Sorry?
I thought you were agreeing that, and you said yes. That's what that means, yes, you were agreeing that.
No, Your Honor. My client concedes that this right remains with the child. However, Mr.
So what is her promise worth? I mean, perhaps the most it is a promise that she herself will not assert the child's right to support. But if that's all that she has the authority to waive, how is she giving her husband any kind of enforceable promise?
Your Honor, even if this court did not feel comfortable with that private agreement, I'd like to point your attention to how Rhode Island calculates child support. First, they take the income of the parent, and here Mr. Monroe does not have a full-time job. He only works sporadically as a landscaper and a handyman.
No.
Yes, Your Honor. This court would then be required to make two deductions. One for his dependent child with Ms. Ruiz, his first child, and two...
How would it work if it was Mr. Monroe who was trying to get the embryos? I mean, let's assume that they divorced. Mr. Monroe married Miss Ruiz, I guess, and that Miss Ruiz was infertile, and so these embryos were Mr. Monroe's only opportunity to procreate with his new wife. I mean, in that situation, would you acknowledge that the balance tipped towards Mr. Monroe?
No, Your Honor, because in that situation, it would not be Mr. Monroe's last chance at genetic parenthood. It would be Miss Ruiz's last chance at genetic parenthood, but Mr. Monroe himself would still be fertile and could procreate with somebody else. Here, Ms. Monroe has no ability to procreate with anybody else. And so the scales in that case would not tip in favor of Mr. Monroe. But if Mr. Monroe himself were infertile, potentially the scales would tip in his favor. However, infertility is not a dispositive factor. This court needs to look at other factors as well. However, in Reber...
When you're talking about factors, you're talking about the particular interests or factors that need to be balanced here?
Yes, Your Honor.
Can you provide us with a list? Can you iterate for us here those factors which you believe should be present in any balancing you want us to conduct?
Yes, Your Honor. This court should consider the financial, the psychological burdens, as well as the fact that Ms. Monroe is infertile.
Psychological on whom?
On both parties, because the balancing test has to balance the sides of both parties. So here, Ms. Monroe would be exposed to psychological burdens because, as I said, these are her last chance at genetic parenthood, and that disposing of them or donating them...
Would that assure that a court in the first instance hearing this dispute would need expert psychological or psychiatric testimony?
No, Your Honor. Mr. Monroe and Ms. Monroe would both have psychological burdens, and the family court below did not discuss the psychological burdens on Ms. Monroe. And if this were to be...
How can we make a finding, Mr. Butler? Are you asking us to make a finding?
Yes, Your Honor.
In fact.
Yes, Your Honor, because this is de novo review, you have the power to do so. And this court should consider...
Wait, back up. You have the power to make a finding of fact because it's the de-novo review.
Yes, Your Honor.
We're reviewing a question of law, and therefore we have the power to make a finding of fact.
Yes, Your Honor.
Interesting.
We have no witnesses in front of us. How can we make factual determinations?
Your Honor, this court...
The other side won in this case really on the contract issue, right? And the trial court only reached the issue you're arguing for the sake of addressing it. It wasn't necessary to address that issue to dispose of this case, was it?
Your Honor, I see my time is up. May I briefly answer
You may
your
answer the
question?
question.
So are you asking that it wasn't necessary to dispose of the contract to reach the balancing approach?
I'm suggesting it wasn't necessary for the court below to reach the balancing test. Since it found that the contract should be upheld, that was game, set, and match, wasn't it?
Yes, Your Honor. However, as my co-counsel stated, this contract should be unenforceable. And so to determine the disposition of frozen embryos, this court should use the balancing approach and find that the scales tip in favor of my client. Thank you.
Thank you. We'll hear from counsel for Mr. Monroe and Ms. Appellant.
Yes, Your Honor.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Caitlin McCauley, and I represent the appellee, Mr. Edward David Monroe. Today, we request that this Court affirm the family court's holding, which found that the informed consent signed by...
You want us to rely strictly on contract principles, is that right?
Pardon, Your Honor?
You want us to rely strictly on contract principles?
Yes, Your Honor, because this contract is clear and unambiguous.
Would that include the concept of equity?
Yes, Your Honor.
Are you familiar with the concept of latches?
Not
Clean
in...
hands?
Pardon, Your Honor?
Clean hands?
Clean hands. Could you
Someone
elaborate?
who has done something, I'm not sure what the adjective would be, but someone who has not performed in a certain way should not be able to come into court and expect enforcement of a contract if he himself doesn't have clean hands or virtuous conduct, for example.
Your Honor, I would not, our client would say that those aren't necessarily relevant here because we're looking at the contract that Mr. and Ms. Monroe signed.
But you just said we have to also consider equity.
Yes, Your Honor, and the equity here would be
Is there an obligation of good faith implied in the contract?
Yes, Your Honor, and there are no facts to show that there were any implications of good faith when the Monroes signed this contract in 2009.
What about during the course of the performance of the contract? Was there any evidence of bad faith at that point?
Not in relation to the contract,
What
Your
about the
Honor.
extramarital affair?
Your Honor, there was nothing in the contract outlining anything between the Monroes and their personal relationship. That's why this contract
Well,
should...
so you're saying the fact that there's an extramarital contract, or an extramarital conduct, has nothing whatsoever to do with the relationship of the husband and the wife who entered into this contract. That's what you're saying.
Yes, Your Honor.
Well, didn't the contract contemplate divorce?
Yes, Your Honor, it did contemplate divorce, and that is why Appellee is seeking for this contract to be
But
upheld.
what is the evidence in the record that these parties really understood what they were signing? I mean, as I understand it, you admit it was basically they had a few minutes in a room and no one to really walk them through these provisions. They're not college educated. I mean, what's the evidence that they really understood what they were giving away?
The record provides lots of evidence to show that both Mr. and Ms. Monroe understood the contract. For one, Ms. Monroe says on page 12 of the record that she agreed that she understood every single part of the contract and it was clear and unambiguous. Furthermore, although opposing counsel says that this was a contract filled with complicated medical terms, each term was explained in parentheses in order to make sure that all lay people could understand.
You don't deny that the very circumstances of why they were there imposed great psychological stress on a couple, do you?
No, Your Honor, but
So why isn't that enough in itself?
it's not enough, Your Honor, because of the additional circumstances which certified that Mr. and Ms. Monroe understood what they were signing and therefore, based on case law, were able to express their intent when
And
signing.
what if they understood it, but they had no choice, or thought they had no choice, but to sign it?
Your Honor, the couple, Mr. and Mrs. Monroe, did have a choice when signing. Ms. Monroe admitted on the record that she knew she always had the ability to ask one of Canton Fertility's agents a question on page 7 of the record. If Ms. Monroe
That's not
wanted...
the same thing as her saying she knew she had a choice. I think you'd agree that had they not signed this agreement, they would never have been able to go through the process they went through with the fertilization. Is that right?
Not possible, perhaps not with Canton Fertility, but it's important to have these agreements.
Or is that yes or no?
That's a yes, Your Honor. But
Okay,
it's
so if they didn't sign the agreement, they couldn't have gotten the procedure. Why isn't that the kind of duress that should have us really think twice before you enforce that kind of contract, given the subject matter of the contract.
Yes, Your Honor. It's not something to cause concern for the court because the parties were well aware of what they were signing. They always had the ability to ask any questions, and they had the option to ask, could they
Why
change?
isn't the cancer that Mrs. Monroe developed in intervening circumstance that really changes everything? I mean, clearly you acknowledge that she should not have foreseen that.
Your Honor, we're not contending that Ms. Monroe should have foreseen cancer, but we are saying that infertility was foreseeable here. For one, the Monroes were at a fertility clinic. Although Ms. Monroe was not infertile yet, it was still an issue that both her and Mr. Monroe were experiencing. Furthermore, studies have shown that when women can go into menopause and therefore become infertile in their 40s and 50s, and Ms. Monroe was 37 when she signed her second informed consent agreement.
This is not a typical commercial contract, is it?
Not necessarily, Your Honor. It's definitely within the realm.
Not necessarily. Is that a suggestion that the question is not susceptible to a yes or no answer? What's not necessarily?
No, Your Honor. It's not a typical commercial contract.
All right.
But it's,
And so you concede that, and of course that's in part what Ms. Monroe is arguing here, that what we have is a contract that is governing future humans, right? And because of that, there is a public policy that's implicated.
yes, Your Honor, there is.
Isn't there?
Yes, there is. And that's why enforcing these contracts is so important.
Why isn't the mere destruction of embryos against public policy?
Your Honor, Rhode Island law has not stated whether these embryos would be considered persons or property, and instead...
Your position is that they're property?
No, Your Honor. We would ask this court
Well,
to...
then they're persons. And so why isn't that a really significant factor weighing in the analysis here?
Your Honor, instead of the embryos being persons or property, we would side with the opinion of CAS, saying they're somewhere in between, and that they are still subject to the signers and the creators of those
You
embryos.
don't think it should be against public policy to destroy even potential life?
No, Your Honor, only if it should be up to the choice of the people who created the embryos, what happens to them since it is their
But you're
creation.
asking the state to get involved and actually order the destruction of these.
No, Your Honor, we're not asking the state to order the destruction of the embryos. We're asking the state to enforce the contract, which has the embryos go to approved research, not destruction.
Hey, what does that mean, approved research? I mean, they're not going to result in a potential life at that point, are they?
As far as we know, we don't know the specifics of the approved research. It would be under Canton Fertility Institute's research umbrella, and we do not know what the actual result will be. It would probably not be induced with life because that would go against the party's wishes here.
That's not going to happen.
No, Your Honor.
Okay.
Does the record show that at the time of review of these contracts, the two occasions,
Yes.
that anyone from the clinic actually went over the informed consent provision with either of the parties?
Your Honor, there was a CFI representative available to ask
Present.
any... Yes, Your Honor. And Ms. Monroe knew that she always had the opportunity...
That doesn't answer the question. Somebody was in the room with them. Did anyone go over the form with them?
The record does not reflect that, Your Honor. However, Ms. Monroe does concede that she always had the option to ask any questions, whether that
If you're
question...
arguing enforcement of the contract, isn't it your burden to establish that, in fact, they did know what the heck they were getting into when they signed this?
Yes, Your Honor, and the record clearly reflects that the Monroes understood what was
There's
in
nothing
the
with that
agreement.
whether or not anybody explained it to them.
No, Your Honor, it does not.
Your adversaries have argued the Reaver versus Rice case. Why shouldn't we be guided by what the Pennsylvania Superior Court did?
Your Honor, here we should more look to the cases that have reflected specifically intentions of the parties and how that relates to the document being enforced. For example, Rhode Island law has found in 2008 in Shappy that a person who signs an instrument of a contract cannot later complain that they didn't consider all the options or they didn't take enough time.
But you're not taking that to the extreme, right? I mean, you acknowledge that there's some things that parties can't bargain away, right?
Yes, Your Honor. However, if...
So let's say that here, the contract had a provision that said if, in order to undergo IVF, you have to agree never to try to procreate outside of IVF. Is that enforceable?
No, Your Honor, because that would be taking away these parties' procreative liberties when signing the document, and therefore would not be enforceable. However,
Out of that, I mean, essentially, you're taking away Ms. Monroe's, you're asking us to take that away, to end that, her opportunity to procreate, so how is that different?
no, Your Honor, we're not asking this court to take away Ms. Monroe's procreative abilities. We're asking this court to respect the document that Mr. and Mrs. Monroe signed, which
Well, what ability does she have if your client wins?
Your Honor, my co-counsel will continue to discuss how Ms. Monroe does have alternatives, such as adoption, embryonic adoption, or even foster care. So her interest in becoming a mother is not halted with this court finding that this contract should
Is
be
that the full
enforced.
scope of her interest, or isn't her interest in giving birth to her own child, in the sense of her own biological child?
Yes, Your Honor, but when balancing both parties' equal rights to either be able to procreate or avoid procreation, that is something that this court should take into consideration because it is an alternative means for Ms. Monroe.
Well, if he has such a big interest in avoiding procreation, why did he enter into this agreement to begin with?
Your Honor, Mr. Monroe does not want to avoid procreation in general. He simply wants to avoid procreation with his ex-wife in accordance with the informed consent that they both voluntarily and understandably signed.
So he doesn't mind procreating as long as it's not with her, is that right?
Yes, Your Honor, because this is somebody who he's no longer married to and is somebody that he
Well, when he got
decided...
involved with his current wife, he wasn't married to her either.
Yes, Your Honor, that is true. However, in this
He had any
document...
problem procreating there, did he?
No, Your Honor, he did not. But when we go to the specific instance of this document, we see that the Monroes both decided that in the event of divorce, they would donate these embryos to research. And they signed this document not only once in 2009, but in 2011. And
What is it really, though? I mean, Mrs. Monroe has been through tragic circumstances. Your client seems to have moved on and been happy. I mean, why don't your client agree to allow her to use the embryos?
Your Honor, it's our client's intention that he believes any children from a marriage should be co-parented, and this would go against his fundamental beliefs and his...
Religious beliefs, or what is that related to me?
It's his closely held moral beliefs based on his childhood experiences.
Not religion? I mean, are we drawing a distinction between moral and religious? I'm just curious. Is there some kind of First Amendment interest he's asserting?
No, Your Honor, we're not asserting a First Amendment
Okay, so
interest.
he doesn't want to be burdened with children, but Ms. Monroe has made quite clear that he has nothing, he needs to have nothing to do with it.
Your Honor, that doesn't necessarily change the fact that this contract is upholding both parties' procreative liberties.
Yes, it is a contract. Isn't it interesting, though, that it's not a contract between the Monroes? It's a contract between the Monroes and CFI, right?
Respectfully, Your
So
Honor.
why should your client be permitted to invoke the contractual relationship against Ms. Monroe?
Respectfully, Your Honor, this is a contract both between the Monroes as a unit and CFI and a contract between Mr. and Ms. Monroe. I would direct the court's attention...
Are you suggesting that there is some bilateral agreement between the then Mr. Monroe and Mrs. Monroe?
Yes, Your Honor. According to page 21 of the record, the second part of the document after the first page, which lists all the obligations to the patient, page 21 has patient and partner. This outlines the details that Mr. and Mrs. Monroe have to each other, and page 27 and 28 of the record outline the disposition agreement that the Monroes had to sign. Although it is an agreement that CFI included in their informed consent in order to make sure they knew what to do with these embryos, it was also an agreement that Mr. and Mrs. Monroe had to make together in
Does
order...
the contractual language suggest any obligations that Mr. Monroe and Mrs. Monroe had toward one another?
Yes, Your Honor. In fact, the language uses words such as we and our, showing that it was a joint decision they had to make, and that according to subsection G, if they wanted to change their mind, they would also have to do so.
It says we and I agree, but what is it that they're agreeing to vis-a-vis one another?
They are agreeing that in the event of any of those contingencies, such as divorce, the Monroes would agree to have the embryos donated to research like they agreed in 2009 and 2011. It's showing that these parties have expressed their intention when signing this document because they were able to understand all the parts, and they chose not once but twice that this was the disposition that they wanted in case any of those contingencies.
Well, you keep using first-person plurals and first-person singulars, but I don't see how that creates any kind of contractual obligations as between the Monroes themselves. Why shouldn't we simply regard this as an attempt by Mr. Monroe to piggyback on the contractual rights of CFI?
Your Honor, this court should consider this document a binding agreement between the Monroes for public policy reasons. If the court decided not to enforce these kinds of agreements, it would have a negative ripple effect, not only...
Does the record disclose what CFI's position is? I mean, should we take by the fact that they're not here, that they're not seeking to enforce the agreement against Mrs. Monroe?
No, Your Honor, this is between two private parties, and therefore it's between Mr. and Mrs. Monroe, whether
What
this
is
contract...
ripple effect you started talking about?
The ripple effect would be negative if the court decided not to enforce this contract. It would have negative implications on not only current and future parties, but also institutions like CFI.
Wasn't there this outrageous speculation? How do we know what impact it would have on the future?
Your Honor, there are 600,000 cryogenically preserved embryos in the United States to date. Although Rhode Island is a small state, it still shows that if we did not enforce these contracts, it would be costly litigation, not only for the parties involved in deciding what to do with their embryos, but it could be costly on the court system as well.
Why wouldn't it be less costly if the contracts weren't enforced? We wouldn't have a lawsuit to begin with. I don't understand that.
Your Honor, I see my time is up.
You may answer.
Could you repeat the last part?
Yeah, why wouldn't it be less costly? Because the courts would not be involved in enforcing the contracts, the litigation wouldn't be here.
Your Honor, if this court chose to enforce this contract, it would be sending a message not only to current and future participants in IVF, but also to the Monroes and institutions like CFI, that these agreements should be taken seriously because they help uphold people's choices when signing about their procreative liberties. And that is why we ask you to enforce this informed consent agreement.
Thank you.
Thank you.
Burke.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Sarah Burke, and along with my co-counsel, Ms. Caitlin McCauley, I represent the appellee, Mr. Edward David Monroe. This case is about respecting Mr. Monroe's right to privacy and procreational autonomy. We would ask this Court...
How does privacy come into this?
Privacy is established based on, and this was just affirmed in McQueen v. Gadberry just 2 days ago, relating a similar IVF case, saying that the right to privacy and equal protection under the 14th Amendment will be violated if either party is forced to procreate against his or her wishes.
But he's already, the act that would be the procreation, he's already done that. He's not being forced to procreate. He's already given his permit.
No, Your Honor. As my co-counsel earlier alluded to, the Coss Court establishes that since embryos enjoy a status above property and not yet persons, these embryos are not yet implanted in a mother or Ms. Monroe. So this is not an issue of procreation to this point. The embryos
Your fundamental position is, in the balancing test at least, is that the right not to procreate trumps the right to procreate. Is that correct?
In this evaluation, yes. However, the Davis Court established the right to...
What do you mean in this evaluation?
In this court's evaluation of the balancing approach, we would ask that Mr. Monroe's right is superior to his ex-wife's.
Why is that? Does that come from the Constitution? Does it come from public policy? Does it come from something in this case?
Or from our values?
It comes from a few things, Your Honors. As the Davis Court, which established the balancing test, suggests, once establishing that the right to procreate and the right to avoid forced procreation are completely equal, the court looks to three things: the positions of the parties, their relative interests, and the burdens imposed by either.
If we look at that, it seems to me you lose. Your client already he's in a family relationship with children. Not biologically is, but I assume he's accepted them as his children. Nothing to the record suggests the contrary. Your opponent, on the other hand, cannot bear children. And how can we look at that as the same situation? We just told that the clock is ticking. Why is that an equivalent situation? Why doesn't that equity greatly favor and tilt the scale in favor of your opponent?
Your Honor, I'll address your question in 2 points. First, that this is a case...
Will either point answer it?
It will. First, that this is a case between Mr. and Ms. Monroe. Mr. Monroe's relationship with Ms. Ruiz and his future children are not part of this examination under the Davis balancing test.
He's concerned about his concept of fatherhood.
That's correct, both financial and paternal. As my opposing counsel earlier stated, there are unwaivable financial duties to Mr. Monroe should these embryos come to term. It should be noted that there is not just 1, but 7 embryos, and as page 27 of the record
When he
reflects,
relinquished his sperm, I'm assuming that he was aware of the fact that in the normal course of things, that sperm could turn into a kid for which he has some kind of financial obligation. Now you're saying, well, the guy shouldn't be burdened with a financial obligation that he put himself in a position to have.
well, Your Honor, at the time, these 2 parties were married. They had signed a disposition agreement with a certain contingency listed. That exact contingency happened, and now Ms. Monroe has thus changed her
Let me
mind.
take you back just so I am clear and understand. You do take the position that of these 2 recognized constitutional rights, effectively privacy rights, if you will, the right to procreate and the right to avoid procreation, are on the same plane?
That's exactly
So
right.
you are not taking the position that at the outset, as a matter of law, the right not to procreate is some slight thumb on the scale favoring your client?
Your Honor, Appellee is contesting that in examining the balancing approach, this court performing the balancing, the scales tip in his favor.
I
However,
understand, but I'm not getting there. I'm not getting to the result. I'm starting with, how do we start out?
well, to
With
your,
that principle of law, and you've answered my question. It's-
So what tips it? I mean, you're saying those rights are equal, what tips it?
a few things, Your Honor. Returning to the Davis factors of positions, interests, and burdens, first and foremost, there are financial and parental duties on my client should these embryos come to term. First, there's a presumption of paternity in Rhode Island under 15.8.1. And second, there's unavoidable and unwaivable financial duties thrust upon Mr. Monroe should Ms. Monroe carry these children. Though she has conceded on the record that she will waive these to the extent possible, according to Rhode Island law, she simply can't completely.
You want our court to adopt the contemporaneous mutual assent test. If the contracts, or if an informed consent provision is subject to being stricken or determined to be invalid, as the other side would argue here, then the next point we have to take is, what does a court do about it? What particular paradigm does a court use to address the parties' positions? And it seems to me that as a matter of legal policy, the contemporaneous mutual assent approach is unrealistic. I mean, how can a court expect that these 2 people who have taken diametrically opposed positions with respect to the agreement they originally entered into can somehow be expected now to reform that agreement, if you will, and enter into another agreement?
If they could, we wouldn't be here. If that was that easy, we wouldn't be here.
To your point, Your Honors, first, that this couple has a long
But
history.
that's why you're advocating the position, right? Because you know you win with that approach.
No, Your Honor.
I mean, is there any legal, is there any legal doctrine that supports that?
Yes, not just in Rhode Island, but all the way up to the Supreme Court as well. In State v. Santos, the Rhode Island Supreme Court stated that the right to privacy protects the right of the individual to make their own procreational decisions. This is exactly in line with the language used in
But that is misleading, because that you're basically asking us to give your client an absolute veto power over this. That if it's a mutual assent, it's not mutual at all. Because unless both parties agree, i.e. if one person objects, it's not going to happen. And that's, you heard me tell Ms. Sachs that I thought that was a totally unworkable doctrine. I'm still thinking it's a totally unworkable doctrine. There's nothing mutual about it.
It is a concern, Your Honor, that this will give one party more power than the other.
It's
However,
reality. It's not just a concern, it's the reality of the situation.
these 2 people have had a long history together. They have 16 years, 6 of dating, 10 of marriage. They've made these important familial decisions before. They have settled absolutely everything else in their divorce
It's an
proceeding.
invitation to continued deadlock, isn't it?
Not necessarily, Your Honor. This is the
It's
benefit.
the second time I've heard not necessarily.
No, Your Honor.
Touche.
The Supreme Court recognizes, specifically in Eisenstadt, that the individual is to be free from unwarranted government intrusion into
Well, I mean, will you
matters.
commit on behalf of your client to engage in good faith negotiations and to take another crack at this?
Of course, Your Honor. There's nothing in the record that states that these 2 parties will never come to an agreement. On the contrary,
You mean you could have mediated this and we wouldn't have to be here?
that would have been the ideal situation, Your Honor. However, these two parties have come together. These decisions they've made in their dating history and marriage they've made together. They've gone through in vitro fertilization.
Some things have changed, like your client's conduct in ending the relationship. That seems to make it less likely they'll agree on this.
That's correct, Your Honor. However, that is not legally relevant. And as to...
Oh, wait a minute. You're arguing the concept like mutual assent, but you're saying your client's conduct that would suggest to us that the mutual assent is not going to happen is not legally relevant. That's what you just told us.
The benefits of using the contemporaneous mutual consent is that it preserves and protects these two parties, the gamete providers, the people who created the sperm and the egg that made the embryo, that the decision is best left in their hands.
It's best left to the objecting party. That's what's left to it. It's not left to their concerns. It's left to the consideration of one person who objects to it. Unless and until that person relents, it's not going to happen. There's no mutual assent. It's, as I said before, it's a veto power.
There's no agreement at this point, Your Honor, but that's not dispositive to the rest of...
How long can the embryo be sustained? Embryos be sustained? What if it takes them 10, 15 years to get around even talking to one another, let alone agreeing with one another? I don't mean this as a bad pun, but what is the shelf life of the embryo?
It is unclear. However, with advancing technologies, it is the time limit is increasing. Embryos only reduce in viability at about 5% every 5 years. That's not such a short amount of time that there's a huge timeliness issue.
If you get into balancing, would you agree that the tie goes to the potential embryo?
No, Your Honor, and specifically because Ms. Monroe has the ability to become a mother by other means, other very likely means.
Well, there's some question as to whether or not she could adopt at her age and given her circumstances. What's the record evidence that she could adopt?
Well, specifically, Your Honor, according to the Rhode Island Department of Children, Youth, and Families, unlike many other states, in Rhode Island, which is at the forefront of adoption, there's no upper age limit for adoptive parents in Rhode Island.
But your opponents argue that she's, I guess, in her 40s now. I'm sure that her medical history is not going to be a plus in the adoption process. I mean, what evidence do you have that she would be able to adopt?
Specifically from this Rhode Island department, they say that adoptive parents in their 40s and 50s are quite common. There is no upper age limit. Across Rhode Island, it is very common that
There's a
parents...
physical age limit, though. The 60-year-old person trying to keep up with a 2-year-old. We're not talking about something where there's an infinite amount of time.
That's correct, Your Honor. However, if Ms. Monroe is so convinced to having children, this other option, and other cases have stated this, specifically JV versus MB has stated that a party wishing to avoid procreation prevails in a balancing test because there exists parenthood by other means.
Let me take you back to what should be our point of departure, and that is the question that I asked the other side. What should be our standard of review on this issue?
Your Honors, this should be a de novo standard, specifically because, as the opposing counsel stated, it's a mixed question of fact and law. The rule choice of balancing versus contemporaneous mutual consent would be a question of law, and the application of the facts at bar to
So
that.
even though you won the balancing, you're not asking us to defer to the trial court?
Not necessarily, Your Honor, because as stated in the
Not
record.
necessarily.
No, Your Honor, you have enough facts before you to make the decision that balancing does come out in my client's favor.
In the balancing, does the embryo, do its interests and potential life factor in at all?
No, Your Honor, as I stated earlier, the costs language that the embryos enjoy a status above property and not yet personhood. That's not specifically relevant
So
to...
potential life has no role in the analysis, not even a smidgen.
Based on the Davis language, which states that it's the positions of the parties themselves, their interests and their burdens, not based on the case law we have before
What
us.
sense does that make? I mean, we've got 2 potential parents and 1 potential life. Why wouldn't you consider all 3?
Because, Your Honor, these are the 2 parties right now that are in the litigation. And further, these embryos they're frozen
Well,
right
you
now.
rely on the interests, the rights under Rhode Island law of the child, if it's born, to financial support as a reason why balancing should come out in your favor. So why isn't it fair to rely on a potential life for other considerations?
Because at this point, the embryo is frozen in time. To use the Witten language, which adopted the contemporaneous mutual consent approach, a status quo is maintained by keeping these embryos frozen at Canton
But
fertility.
that's the false part. That's my problem with Witten. Status quo is not maintained because it's not, the embryo may be frozen in time, but time is not frozen. And to the extent that time progresses, it increasingly gives your client a heavier hand and a heavier bludgeon to use because your client can single-handedly dictate the terms of what's going to happen.
Nonetheless, it is Appellee's contention that these decisions are
It's
best
nonetheless the
left.
same as not necessarily.
These decisions are best left to the parties themselves, even if
Well,
that
they won't be
means.
left to the point. That's exactly my point. It will be left to your client. Don't blame me for arguing that, because you win. But it's not going to be left to these two individuals. And you're focusing on her right, her ability to adopt. Doesn't that cause us to then get in and make a value judgment as to how we view adoption vis-a-vis one having their own biological child?
No, Your Honor. The possibility of alternative means to parenthood is completely different than biological childbearing.
Well, why shouldn't we let her decision as to her own value she places on adoption vis-a-vis her own biological child? Why shouldn't we weigh that in the balance, not necessarily the fact, well, kid's a kid, a kid. Why shouldn't we let her preference control that assessment?
Because specifically, Ms. Monroe's ability to achieve her dream of motherhood will not violate, by adoption, will not violate Mr. Monroe's right to avoid
Well, her
forced
dream is not to
procreation.
achieve motherhood by adoption. That's not her dream.
No, Your Honor. However, courts have stated in performing these balancing approaches that when there is this alternative means, that should tip in the opposing party's favor.
Is there anything unique about the record in this case that changes the balancing analysis compared to the other cases?
No, Your Honor. To my opposing counsel's point that this is Ms. Monroe's last chance. That is equally a last chance for my client. Once his right to avoid forced procreation is violated,
What about the fact that she developed cancer and the fact that your client had an affair or left the relationship? What about those factors? Aren't those unique?
they are unique, Your Honor. However, those have been considered by other courts, yet not factoring into a balancing approach. They are resuscitated in a statement of the facts, and yet they are not considered in a balancing
Do you
approach.
think we have to ignore them?
Not at all, Your Honor. However, they're not dispositive to the data's factors established.
How should we view ourselves as forcing an adoptive relationship on someone? Because that's what you're asking us to do. She doesn't want to adopt, she wants a biological child. You're saying, well, it's parenting, it's parenting, it's parenting. So you're kind of asking us to force her into an adoptive parent relationship. Is that something the court should get into?
No, Your Honor, and that is exactly why Appellee would advocate for the mutual consent approach, because it removes the court as a decision maker, substituting the court as a decision maker when it should be
And
left to
that's your
these two
client, the
parties.
decision maker.
I'm sorry, Your
And
Honor?
that's your client, the decision maker.
That is a concern, Your Honor. However, that's not always the case. Right now, despite Ms. Monroe's unfortunate current circumstances, it is neither fair nor just for this court to compel and judicially compel parenthood upon my client.
Thank you.
Thank you, Your Honors.
Who will argue in rebuttal for the appellant? Ms. Sachs?
Your Honors, 1 point on rebuttal. When embryos represent an individual's last chance at biological parenthood, every single court has found in favor of the party seeking custody of the embryos. In Reber and Zafransky, I'd like to point your attention to the facts of those cases. In those cases, the women were diagnosed with cancer, underwent chemotherapy, and were rendered infertile. In both of those cases, the court granted custody of the embryos to the women. Thank you.
The court, having at this point heard the arguments of both parties, we will recess to conference the case, and I expect we will return sometime this evening with a disposition. Please be seated. It is customary at Moot courts for the court panel to say a few words and make some comments, which we hope will be helpful, but to make them whether they're helpful or not. And you, of course, are required to sit here and listen, but you don't have to really. So with that said, I'm going to call on my two colleagues to offer some comments. And if there's anything left to say, I'll have something to say as well. Justice Garrett?
Okay. I thought you guys were all great. I mean, this was a tough hypothetical case. These guys are really tough.
Yeah, I'm a pussycat, this guy.
So I really thought you all did terrific. Cody, I mean, you had a really good, confident presence. I thought you did a nice job using the authority. Kim, I thought I gave you a hypothetical. You had a great answer to the hypothetical. You kind of turned it around on that. I was really impressed by that and your ability to stick to your guns. I mean, you did a really nice job with that. Like I said, I really liked your rebuttal. I mean, it was short, to the point, and anytime you can say that every other court has gone the other way, that's a great thing to say. So that was, I thought, very strong. Caitlin, terrific job. I thought you had a really nice opening and closing too. You had a great knowledge of the record. I think I pressed you a couple times in the record, and you came right back with cites to the record, information in the record. I thought that was very effective, and you had really good understanding of the principles as well. And so I thought you did a really nice job. And Sarah, the same. I thought we gave you they gave you a hard time.
Yeah, we did.
But all of you really, you stopped when you got a question, you were responsive, and I thought you did a really nice job with that, and sort of keeping the focus on the principles that were important to you, and being able to go back and forth between the balancing arguments and the contemporaneous mutual content, which Judge McKee was not a big fan of. I thought the closing was very strong too, and that was a nice way to end the argument on your side. So great job, all you guys.
Judge McKee.
Yeah, I echo that. It was really a great job. The rebuttal was really excellent. When it was a rebuttal, we don't hear a lot of those. People usually say, just a few points you I'll be brief. And then they go on and it's not a rebuttal. Well, we regurgitate what was in their main brief or their main part of the argument. But the rebuttal was succinct, and it was actually a rebuttal. Everyone had a wonderful command of the record and of the cases. And you also, as Greg said, you stopped when a question was asked. There are a few things. I was at a class at Penn the other night, and I was asked, what are the most basic points of the argument? I said, you're not going to believe it. It's letting us ask a question, listening to the question, and then answering the question that was asked. It sounds really basic. And when it happens, it's almost like nirvana. It doesn't happen all very often. But everyone here let us ask the question. They didn't have to wrestle to get space out of you to ask the question. You say answer the question. The answers weren't always responsive, but that's okay, because sometimes the questions were designed to hurt you, and if you answered this question the way it was asked, you've been in trouble, and always you recognize that. So you answered the question you wanted to be asked rather than what it was asked, and that's not, as long as you know you're doing it, I think that's okay. I would say to Ms. Sachs especially, I sympathize. I have exactly the same problem. I speak much too rapidly, and I also tend to mumble. You don't mumble, so you're way ahead of me on that, but slow down, and just pace yourself a little bit, and just slow down. I know why you do it, the same reason I do it. You're afraid you're not going to get everything out you want to get out, so you just kind of let everything fly out. And as I said, I can sympathize with that when you're arguing. I thought to myself, I kind of feel sorry for you because I've been there, I'm still there, I can't slow down.
No, we can't.
You're really good, but that's something you really need to work on. Just slow down a little bit in your presentation.
Well, there's little to nothing that I can add to comments made by my colleagues. All four of you really do your stuff. It is a difficult problem. Many years ago, I spent a few years as a state court judge on a small court. Judge McKee was also a state court judge years ago. He was assigned to a division. My little court, we heard a little bit of everything, civil, criminal, and family. And this, in some ways, took me back to some excruciating experiences in family court. It's a tough problem. It's an interesting problem. The fact that there's not a lot of law and certainly no clear dictates here to any of you make your jobs more difficult and you all handle them well. I would second Judge McKee's comments about slowing down delivery. Several of you, and it's perfectly natural where you're pumped up and perhaps a little bit intimidated to be in front of a panel you've not been in front of before, or talk a little more briskly than you ordinarily would. To just also follow up on something Judge McKee said, but in a different way. Something to remember about oral argument is that you have a very finite amount of time to leave the panel you're before with impressions. You have a very short period to make the points that you want to make. That having been said, Judge McKee's point about answering the questions that you are providing is enormously important. We know that advocates come in wanting to say what they want to say. But in our court, where not every case gets oral argument, we determine whether or not we want to hear argument in your case. We know what we want to hear. And what the advocate needs to realize is if you're going to make points with us, satisfy us. Don't say what you all rehearsed, came in determined to tell us, because first of all, you probably said that in your briefs. And we read them, and the Third Circuit, we prepare heavily. We're known, I think, by most of the bar as being a hot court, and I mean that on the basis of the questions we ask in the preparation. There's no way two guys like us deserve to be hot. We sit together a lot, in case you know, colleagues for 14 years, and sat together just last week.
I've been hot all 14 years. Keep us warm.
That's right, that's right. I'm a straight man. But really, you must go in with that recognition. A short amount of time to accomplish what I want to accomplish, but what I want to accomplish is convince these folks. And to do that, you have to answer what we have to, we have indicated we want to know, want to learn. All of you knew your material very well. Nobody used any gimmickry, which I like. We've seen that in a courtroom from time to time. I've seen it in moot courts. You know, you prepared a lot and you had this idea on how it might be cute, possibly effective, but catchy. Not a good approach with an appellate panel. I was reciting the other day a story I remember about years ago, watching an advocate stand up and start the argument in front of a panel and a particular judge, a wise judge, a little bit of a curmudgeon, but not too much. And the lawyer said, "Your Honor, this is really a straightforward matter. There are only 3 points you have to keep in mind. Number 1, read the rule. Number 2, read the rule. Number 3, read the rule." And the judge leaned forward and said, "Counsel, I think I'm with you on point number 1 and point number 2, but could you help me with point number 3? That could be deflating." Nobody tried that kind of thing, and on appellate panels, it's not effective. as the three of us have said, you all did a remarkably good job with a remarkably difficult, but also remarkably interesting case. The writer, is the writer the problem here?
Congratulations.
Nobody ever gives McKee and I applause.
I'm humbled, thank you.
Take it for what it's worth.
You earned it, you earned it.
And we want to thank the entire Moot Court team here, because they are a team. They made us feel very welcome. Their preparation was superb. We were provided with all the materials we needed in a very organized fashion, for which I know all three of us are very grateful. And hey, you're going to give us free drinks in a bit.
All three of us.
Yeah, we're not going to knock that. So anyway, we've reached the point where we do need to declare winners, and that's always a difficult thing. Always a difficult thing where we have a problem of this profundity, and advocates who have, yeah, that's a word I'll teach you later on. But anyway, we must announce a team winner and a best oros. And the panel has determined that the Appellee's team is the winner. And we have also determined that Sarah Burke is the best oros.